to interrogate the constitutional philosophy of judges who are going to sit on a constitutional court. Mr. K.N. Bhatt stressed the need for the composition of the National Judicial Commission to be written into the Constitution itself and not left to ordinary legislation. He expressed the apprehension that every other day then the composition of the Judicial Commission can change depending upon expediency, exigencies, and depending upon parliamentary displeasure with the kind of judicial appointments which are made. They may bring in reservation, etc. Now, I think Mr. Bhatt has raised a very, very valid concern that this cannot be something so temporary, so fleeting. I would only ask you to consider the other viewpoint. If something is embedded in the Constitution, then it becomes rigid. On the one hand, we need a reasonable degree of permanence. On the other hand, embedding something into the Constitution should not make it so rigid that it becomes difficult to change even with the benefit of experience. The chairman, Mr. Venugopal, made 2 or 3 points with which I would like to differ, and I hope that stimulates discussion also. He said that the majority should be judges in the proposed body. My view is that the judges should be marginally outnumbered. Judges should, of course, be strongly represented, but keeping the principle of democratic accountability in mind, my submission is that judges should be marginally outnumbered. He made the point that the eminent members should not be lawyers. Now, in South Africa, lawyers and solicitors, or barristers and solicitors, are separately represented on the Appointments Commission. They bring in a very rich input. Lawyers who would be appointed to this commission would be senior and towering members of the bar, and if they are appointed by this collegium of the Prime Minister, Chief Justice and Leader of the Opposition, they would be persons of true eminence, and I don't think we need to worry about a lawyer on this commission taking an undue advantage of the fact that he's been on a Judicial Appointments Commission. Mr. Venugopal also highlighted the fact that lawyers with party affiliations are appointed to the high courts. Now, I think what Mr. Venugopal had in mind was the state of Tamil Nadu largely, where it is known that some are DMK judges, some are AIADMK judges. Now that is something, of course, which needs to be deprecated, because persons are appointed only on the ground of party loyalty. But I wish to offer a slightly different perspective, while agreeing that narrow party loyalty should not be a ground, should not be the sole qualification for appointing someone as a judge. I only want to stress the fact that judges who have come from a political background in a larger sense, who have rendered great public service, in fact, bring rich inputs into the judicial system, and so judges with a political background don't have to be excluded per se. The system will be poorer for it, and I just want to give you the names of some eminent judges, some of the distant past, some of the more recent past, who have enriched the judiciary, judges both with left backgrounds and with right backgrounds, who have been great judges. Let us start with Meherchand Mahajan, K.S. Hegde, Krishna Iyer, and in more recent years, Rajinder Sachar, Rama Joyce, and P.B. Sawant. These are all judges with political pasts who have only enriched the judiciary, and therefore my submission is that a political background is not necessarily a bad thing. Thank you.
Thank you, Raju. But before throwing open the discussion from the floor, I have to defend myself as to why I said that the judges should be in a majority. And this is because of what the judges themselves had experienced in the early 60s, 70s, 80s, and so on, till these judgments were delivered. The Chief Justice of India would send a list of names for the High Court or the Supreme Court, which had been recommended by the Chief Justice of the High Court, or where he himself had decided that they should be elevated to the Supreme Court as part of the consultative process, instead of the names emanating from the President of India. And when you say President of India under the Westminster system, it means a Union Cabinet. And when you say the Union Cabinet, it means a party in power. Now, the law minister would send back that list with his own names, persons who, according to him, were persons who were like-minded, because they had to have some leftist leaning at that time, and they would be added and it would be sent back. Some of the names would be deleted from the list sent by the Chief Justice of India. The Chief Justice of India would look at the names. He would be totally unhappy with them because he knows that they had party affiliations or their leanings were too much to the left or whatever it is. Therefore, he would send back the list. This list would then be kept by the law minister interminably. There was no concern about the fact that there are vacancies and a large number of vacancies. And the net result was, finally, the Chief Justice had to surrender and say, all right, out of the 4 names you have suggested, I will accept 1 or 2. But otherwise, the rest of them you would appoint. This is what was happening, where they decided that so far as any political party in power is concerned, there is too much of a temptation to ensure that you had your, not camp followers or anything, you had persons who are like-minded, who would appreciate the land reforms laws, the laws which are being passed for nationalization and so on, which resulted in 25 amendments in the first 10 years of the Constitution. Therefore came this attempt to bring into existence the collegium by first converting, so far as consultation is concerned, into concurrence, and thereafter having 5 judges of the Supreme Court alone deciding the destiny or the future of the lawyers, future of the judges of the High Court, for appointment to the High Court and to the Supreme Court. That's the reason why I said we have to have a majority on the commission of judges from the total number including the eminent persons. But the check on these judges will be if they are using the majority to bring in undeserving persons, to bring in persons whose credibility is under question. So by overlooking persons who were far superior, they have to record reasons. They have to record reasons because seniority would be one among the criteria. And they have to record reasons as to why they are overlooking the person who is much higher seniority, who has great credibility, who has a track record of excellent judgments. Here I say that there has to be a database which is totally not looked into. Every High Court judge before being elevated to the Supreme Court can be tested by looking at his own judgments. If there is a database which is maintained of the best judgments delivered, one judgment each year of a judge. After all, there are only about 620 judges. There are so many law clerks, so many interns. If they are put on the laptops and the computers, they will be able to identify excellent judgments and bad judgments. Those have to be looked into. You can't just have it in vacuum saying, I hope once he comes to the Supreme Court, suddenly he will, his intelligence will improve, his background experience will improve. Therefore, according to me, there has to be a majority of judges so that they cannot be the political wing of the state cannot roll, as it were, their own candidates. All right. Now, with this, I would...
just
yes.
Just 2 minutes on this. See, Mr. Ramchandran is absolutely right. There were, he mentioned great names who were actually came with a political background. But I must tell you that those are things in the past. When my predecessor, Justice Katju, was the Chief Justice, he scrapped one list because it was completely dominated by, all worthless lawyers. They were included, their names were included because they belonged to either the ruling party in the center or wherever. Then he completely changed the list. When I tried to send my first list, there was a communication from the Chief Minister saying that these names should be considered. Again, the same logic is that the social philosophy, etc. But I found that the names which were recommended were of a very poor quality lawyers because they were loyal to the party. So I'm not sure whether in the present situation we are going to get great judges from the political background. So I feel that perhaps Mr. Venugopal is right that we should have a majority of judges on the
I think this should be a matter where we could have contribution from the floor as well. Now, we welcome questions. You will direct it at a particular speaker or the chairman, vice chairman, co-chair, and you will also indicate or identify yourself before asking the question. Give your name and then ask the question.
I am Charan Lal Sahu, Advocate, Supreme Court of India. I have no quarrel so far as the present amendment bill is there. But whether it will serve the purpose or not, because all laws, especially 1860 IPC and 1861 CRPC are coercive laws. During the freedom fight,
you may have to ask a question, Mr. Sahu. You have to direct a question in regard to the topic.
My problem is this, even though there are good judges and law is bad, like during emergency I fought ADM Jabalpur and Bhopal gas case. So what is the use of this system if the law itself is bad? Therefore, we should not quarrel about the quality of a judge or his integrity, honesty, etc. This is nothing.
Okay, we understand.
So law should be amended and law should be liberal and it should be according to the socio-economic conditions of the country after 1950.
Okay. Raju, would you like to answer that?
It's an observation, it's not a
Okay.
question.
Oh yes, that's an observation. Okay.
May I ask a question? I'm Rajiv
And
Datta. I'm
after
a
that,
senior
I think-
advocate practicing in Supreme Court. My question can be answered by anybody from the panel here. we heard Mr. Venugopal say that no practicing lawyer should be a part of the commission. Raju had a different view. I was wondering, why should we not have some representation from the Bar Association? I mean, President Bar Association of India, President Supreme Court Bar, or elected persons from the bar. Because let me also say, just a second, who are you selecting? You are selecting people from the bar, and you are not getting any input from the bar. Please, I mean, I would suggest that you should have somebody from the bar.
Actually, to answer your question out, the Bar Council of India has demanded that its chairman should be a member of the committee. Therefore, I think that suggestion is already there, but it's a welcome suggestion, as you've seen from the applause which you have received.
I am Keshav Dayal, I am a senior advocate, and I am also concerned with SARC law and some other bodies. I have my questions directly in point with respect to the same point out. And my question is to Mr. Venugopal as well as Mr. Ramachandran. My question is, lawyers are the most fitted persons. Lawyers and jurists are the most fittest persons to be part of the eminent persons. In fact, I will go a step further. I will say it should be qualified that these two eminent persons to be nominated will be lawyers and jurists and nobody else. Because it's my firm conviction that lawyers are not respecting themselves and they are depending on judges, ex-judges, and hundreds of other persons. I have a great respect for the lawyers and the lawyers community, and there are senior lawyers and there are other jurists, authors also on law subjects, law teachers also. They are most eminently suitable persons to be selected for selection of judges. This is my point.
Appear. The question is, number one, what is the reaction of the judge when a person who has appointed him and to whom he owes his appointment or recommended it, he appears before him? Secondly, what is the reaction of the clients who know that so far as this gentleman is concerned, who is there as a lawyer, he is an eminent person. Therefore, by the very definition of eminent person, he won't want to take advantage. But the client would believe that so-and-so is concerned, he is having a close, the judge would perhaps lean in his favor. That feeling should not be there. I know as a fact that there have been murmurs when a law minister who has appointed judges, later after retiring when he practices, appears before those judges in the High Court. Now, in which case, so far as the bar is concerned, they generally feel that's not correct. Therefore, that is why. But Raju, do you have a different view?
No, my view, as I said in my summing up also, is that the legal profession is an important stakeholder in the process of judicial appointments, and therefore, this misuse, you're rightly saying, Mr. Venugopal, that an eminent lawyer will not misuse. Equally, a judge being appointed to a superior court, we should assume, otherwise he is not a judge, if he thinks that I'm going to give an order to this person because he was on one of the members of the Judicial Commission which appointed me. So this commission should appoint judges of such caliber who will rise beyond this personal gratitude. Secondly, I would disagree with Mr. Keshav Dayal only on this, where he seems to suggest that these two eminent persons should both be from the legal fraternity. There I strongly disagree, because I think, as you have in England, lay representation is very important. After all, the public are the consumers of justice, and therefore at least one of those eminent persons must be an eminent citizen from any of the different walks of life. And I'm sure that if that eminent citizen is again going to be chosen by this collegium, whether it's an eminent lawyer, jurist, or eminent citizen, I am confident that the person would be of really great eminence representing civil society at large.
One minute. May may I elicit the views on this suggestion? Instead of the Bar Council of India chairman or the Bar Association of India chairman or the Bar Associations of the states, high courts, president, being on the committee, why not have them as consultees where the National Judicial Appointments Commission will consult the Bar Association of India chairman and the Bar Council of India chairman, and in the case of appointment of a High Court judge, the Bar Association president of that particular High Court. Therefore, that perhaps would also bring in your idea that there should be an input from the bar itself. All right. No, I think Justice Shah would just...
interjection on the point of the lawyers being considered as eminent persons. In almost all commissions, there is a representation to the bar. UK, South Africa, everywhere. But this is a dangerous idea of taking the elected person of the bar or the association on this committee. That as Mr. Ramchandran says, that eminence is very important. The person should be beyond any controversy, and he about his credibility nobody would question. But there has to be some contribution from the bar, whichever way, in the consultative process, or but that's very, very important that the bar knows about it.
Okay. I am MS Prasad, Senior Advocate and Office Bearer of the Bar Association of India. I have one question to Justice Shah. You have been saying that we have been working up, for the last several years that we need to have a judicial commission, and when the government brought it, there is a lot of opposition. No, in fact, we don't have opposed, like Mr. Bhatt says. We welcome it, but there are two issues which we have been opposing is that we don't want a general law to make a national judicial commission which can be changed by the parliament even by an ordinance, government by ordinance. So we need to be the part of a constitution for independence of judiciary. The National Judicial Commission composition should be part of the constitution so that whenever it needs to be amended, it's amended with the proper protection. That's a major important issue. And then the constitution of the National Judicial Commission also can be discussed. There can be whether one judge more or one judge less is not a big issue. Ultimately, when everything is transparent, like since we are party to various collegiums, as we see in our state also, it happens overnight, late night in the night, 11, 12 o'clock, people come and sign those things. And people are taken by surprise by the inclusion of people who are never known to have any great practice. It happens in the High Court and the Supreme Court, I need not say much. You are aware of it. So there has to be transparency. And regarding the consultation, that's what I would say. Instead of having eminent jurists, maybe one or two could be there, who could either can be non-practicing lawyers or lawyers of very great eminence may not be misusing that. But more than that, the bar has to be consulted. The bar, you can give the names. These are the names that have come forward. What is your opinion? It can be consulted among the bar members and express, yes, this is the view of the bar. That happens in various other countries also. The views of the bar is